We get asked a lot, what is a bad faith claim? It's easy to understand if you think about an insurance policy as a contract. And actually that's what it is. And just like every other contract, there are written provisions. I will pay you a premium and you will give me coverage. And there are also implied provisions. And one of the chief implied provisions of any contract, but especially an insurance contract, is the implied covenant of good faith and fair dealing. When an insurance company breaches the implied covenant of good faith, it's said to have acted in bad faith. And there are lots of ways that an insurance company can breach an insurance policy contract. One of the chief ways is a breach of the duty to defend the insured. There are lots of ways that happens. One of them is by taking too long to review the claim once it's been tendered to the insurance company by the insured. That delay can put the insured in jeopardy. So, acting quickly is one of the implied provisions of an insurance policy contract. The insurance carrier is supposed to look for ways that there is coverage, not look for ways that there isn't coverage. And as the insurance company reviews the policy, it's supposed to take whatever ambiguity exists in that contract. And remember, they're written by lawyers for insurance companies, so ambiguity is their friend. But the insurance company is supposed to take that ambiguity and interpret it in favor of coverage. That's the law. That's what the insured expects from the policy. Once the insurance company sees that there is coverage, it's required to assign a competent attorney to defend that claim. So if you've got a professional negligence claim on a real estate brokerage policy, the insurance company can't give you a lawyer that does nothing but automobile accident defense claims as your lawyer. Now, that duty to defend isn't absolute because there are exclusions from coverage in a policy. What happens though when you've got a claim that's made and it includes allegations that are covered and allegations that aren't covered? When you have that blending of claims that are covered and not, the insurance company's duty to defend is broad enough that it has to give you a defense against all of those claims, but it doesn't have to pay for damages on the uncovered claims. When an insurance company has that mixed claims kind of event, it issues what's called a reservation of rights letter. That reservation of rights letter says, we're going to defend all of them, but we're not going to pay the ones that aren't covered. Now, when you get that, it triggers what's called humus counsel. You have a right to an independent lawyer, not the lawyer picked by the insurance company. If the insurance company doesn't tell you about that right, that is also a breach of the duty to defend because you're entitled to competent defense. And by the way, the insurance company has to pay for that independent lawyer that you pick. And if they don't or don't do it timely, that's the same as not giving you a defense, and that is also a breach of the duty to defend. The duty to settle a claim is another one of those implied duties under an insurance policy. And it seems a little counterintuitive that the insurance company has a duty to settle a case, but it does, especially if there are those mixed claims. If you've got a claim for negligence and it comes along with a claim for intentional fraud, and most plaintiffs, especially in a real estate case, will always claim both, the insurance company might be presented with a settlement proposal that's within the policy limits that settles all of the claims. It's got to accept that settlement within policy limits because that's what offers you the most protection, even if it includes, as part of the settlement, resolution of the uninsured claims. The other thing that an insurance company needs to do, which is part of that duty to settle, is settle fairly with respect to the amount of the claim that it settles. For instance, if you've got a policy that covers the elevator shaft in an office building and there is some damage, the insurance company can't tell you, here's $50,000 to settle the claim, when really the damages cost about $150,000 to repair. So a good faith analysis of the loss is also part of that duty to settle a claim that's given to the insurance company. Another thing that we'll see a carrier do is underwrite the claim after having given coverage and deny a policy, sometimes rescind a policy after it's been issued. It's called post-claim underwriting, where you've received a policy, you've had it for 6 months, and then a claim comes in and the insurance company looks at the application again and decides, based on the claim that's been presented in the application that it got, that it wants to rescind the policy completely. There's very limited circumstances where that can happen. If you've actually lied in the application and defrauded the insurance company, tricking it into giving coverage in the first place, they have a right to post-claim underwrite. But absent an outright fraud on an insured's part, it's very difficult for an insurance company to rescind coverage after the policy's been issued. It's important to remember that in a bad faith claim, you have the right to assert a demand for punitive damages against the insurance company. That's different than a claim for breach of contract, because punitive damages aren't allowed in a breach of contract claim. If you're not sure whether you've been defrauded by an insurance company, whether the insurance company has acted in good faith with regard to the defense of a claim or the appraisal or settlement of a claim, and if they've canceled your coverage after you've tendered a claim, you should check to see whether you've got a bad faith claim. You should come and talk to us.